Okay. Had some good questions come in. This one, we had a level 1 snow emergency on January 6th. 7 government offices closed for those days, and employees paid for those days. The sheriff asked the commissioners and myself if we could compensate the employees who had to work or reward to work on those days declared snow emergency, like highway drivers, deputies, dispatch, etc. The highway director also asked if we could pay overtime for the highway truck drivers who stayed overnight at the fire stations, even while they were sleeping. How many had this problem or over these weeks? I mean, this year's been rather severe, as we all know. This is a question I get every January or in December if it snows early. It's not legal. The sheriff showed up here at our commissioners meeting today and said, you got to pay my guys extra because you sent all the women home at the courthouse. And these guys had to be working. And that's not fair. And truth of the matter is, what's the purpose of the job? We want public safety people working in these emergencies. We want the non-public safety people to stay home, stay off the roads. We closed the courthouse because we recognize that, and we don't want to jeopardize the safety of our employees to try to make it in when it's not possible. So we have this emergency closing policy. How many of you have emergency closing policies in place right now? How many don't? Anybody? Most of them run something like this. If we close a facility, then those people who were working at that facility, sent home or told not to come to work, we'll pay them for that day. Now, here are the exceptions. You're on a beach in Puerto Vallarta, Mexico, and you learn that the courthouse is closed. You're not going to get another day off. The penalty for those people who had to suffer through the storm is enough just to know that you were there. So if you've already requested a day off for a vacation, if you've already called in sick, if you've already made arrangements for that to be a personal day, then that's what it is. But for those people who didn't and did not work at that facility that was closed or later closed and sent home, then normally the policy is to pay those people. Again, from this morning, to do that though, you need to have a policy that says that. You just can't say, Mr. Commissioner, what do you think we ought to do? Well, go ahead and pay them all. Not without a policy. If you have a policy, you can. But the problem is we can't pay people for not working without a policy. That's ghost employment. And that's a felony to either take the money, employee or employer, to authorize payment of time not worked. So we've got to have a policy to pay. So most generally, the policy is to pay those people who are affected by a closing. Do we close the jail? No. Now, if the jail were on fire, we would be moving those prisoners to another facility, and we would still need all the jailers, probably more, to be called in. The police are on duty 24/7. The highway people, we want out there clearing snow. So those people are all, that's the job. That is the job. So they're going to be governed by whatever the overtime policies state. So we're back to, if they go over the 40, they're going to get time and a half. And if they're counting time off, or if they're holidays or all that counts, then they're going to get to the threshold quicker. If it is physical hours worked, actual hours worked, they're not going to get there as quick. But again, that needs to be a policy. There are some counties that also tag in a couple of other exceptions. One is if you're a public safety person required to work and be called out, we will pay you at a higher rate during that emergency. Again, you can have that policy. Do you have to? No. You only have to do back to the floor, not the ceiling. So if you want to go beyond what the wage and hour rules are, you can do that. But that is a call of each individual employer. But there are some policies that say, no matter what, if we're calling these highway guys in the middle of the night, we're going to pay them at time and a half no matter what. During that time, we're going to do that. Or we can have a policy that says, if you're on call, if you're the one guy that's on call in the highway department that has to come back and get a limb out of the street in the middle of the night, we're going to pay you some additional compensation just for the mere fact that we've put you on call and you're the guy that's going to have to go out. There's call-out policies. The guy gets called out is going to get a minimum of 2-3 hours compensation regardless of the time it takes for them to do whatever they're called out to do. The maintenance guy has to come back to the courthouse, looks around, flips a switch, goes home, spends 45 minutes. We're going to pay him 2 hours no matter what. The inconvenience of calling him out. So in those cases, they need to be, if the not only the commissioners, but if the council, this is a pay policy, by the way, if the council and the commissioners agree that extra compensation ought to be afforded these people who work during emergencies that are declared, then they can pass those policies. And if any of your commissioners, council, yourself, we've got some model policies for that. If you contact me or our office, we can give you some direction on some model policies for that. The problem, another problem that creeps up is if there's a declared emergency in Hamilton County and I work for Madison County and there's not an emergency. I'm told to stay off the roads in Hamilton County, but Madison County's not having that same level and they're expecting people to come to work. There's another area where you need to have a policy that's going to explain how are you going to treat those cases. And I think arguably, somebody can say, I'm not to be out traveling, I can be arrested, then how are we going to treat that? As far as sleeping at the fire station, that's not considered work time, even for firefighters. And the rule for firefighters is that if they get, I believe it's 6 hours, if it's not uninterrupted sleep, that can be deducted from their work time on a 24-hour shift. If they're on 24-hour shifts, but if it's interrupted time, then they're going to have to be paid for those interruptions if they exceed a certain amount of time that they're out on a call. And that kind of gets, fire departments do not like to calculate time with the exclusion of sleep time. That's why you'll sometimes see that firefighters and paramedics, EMTs that are on call 24/7 and spend the night on station, that those hourly rates will be lower to cover all 24 hours. They can't be lower than the minimum wage, but they'll be lower than you might expect if they were regular 8-hour, 40-hour a week people. Did I answer that? Whoever's question makes sense?
Can you elaborate? When you say if somebody else lives in a different county and they work for one county, and their county called their state of emergency, you didn't answer. Should we pay them?
You need to have a policy that handles that situation. You might have a policy that says, you can use your available paid leave time or it's unpaid. I mean, you don't have to pay them unless they work. That,
Our county's closing because of state of emergency, that's different. They're in another county and they work for us. So we just gotta make it specific.
yeah. Also, the emergency closing, we're into this weather right now. It's fresh, but there's also a power outage. A power outage at the government center closes the government center. The courthouse is still open. Do we send everybody in the courthouse home too? No. Now, are we going to get the whining? Yes. You sent all those people home. That's not fair. We had to stay here and work. You know, the air conditioning went out or the heat went out, electricity went out, whatever. But we're sending, that happened, no fault of the employee that it happened, but this is how we're going to treat those employees that are affected by a facility closing. We're going to close the highway department? No. We're going to close the jail again? No. But we may close one facility and not another, and we treat those people the same way. Departments that function 24/7, sheriff dispatch, if schedule has an employee working 9 days in 1 week and a 2-week pay period and 10 in another, should we be paying the same every pay period, or should pay fluctuate depending on whether 9 or 10 days? Good question. This is Garcia Law Covered Dispatch. Whose question is this? Garcia. How's it?
You picture Rod and Marcia and I having this discussion yesterday.
I can. Now, these people who are in public safety who have fluctuating schedules, there's a number of schemes that you can establish to pay them. One being, you can pay people a salary fluctuating work schedule, okay? Where they would get the same salary every week, no matter what the schedule is. However, if they go over 40 in one of those weeks, we owe them overtime for any time over 40. Now, here's what kind of sounds goofy, and I've always had trouble explaining it. Let's say that week 1, I work 36 hours. I get a salary. The next week, I work 44 hours. I get the same salary. However, those 4 hours, I need to have my overtime taken care of, okay? Now, the salary covers all time worked. So it covers all 44 hours. I've been paid, quote, the straight time already for all hours worked. So so I'm owed the half. Not time and a half for the 40. I've already been paid the time. I just need the half. Now, the way to figure that is to divide the 44 into the salary for that week to derive the straight time rate for 44 hours and then figure out what the half would be. Okay? Problem is that will change depending upon how many hours I work over 40. That number will be different if I work 46 hours. It'll be different if I work 41. You make the division into the total number of hours I worked to come up with a straight time number based upon how many hours I worked in that week. And you only have to do it when they go over 40. If they work 38 one week, they work 35 another week, they're getting a salary, that's it. You're only worried about the calculation during those times when they exceed the 40 hours in the work week. Does that make sense? Is that helpful? Did I answer the question?
I think so. So it doesn't matter, I mean, you pay them the same, this, like 9 days on this pay period, like 10, assuming that nobody goes over 40. You get 9 days this time, 10 days the next time, they're making the same every time. Okay?
The other option, I said there's more than one scenario or scheme. Another option would be to convert their salary to an hourly rate. So in that scenario, they would be paid their hourly rate for the total number of hours they worked that work week. So in those work weeks where they worked less, they would be getting less in the way of a check. Those weeks they work more, they'd get more. And again, but every 7-day work period stands on its own. We say sheriff and dispatch. The sheriff could be put on that 28-day schedule. Sheriff's deputies. Dispatch, no. Dispatch had to be paid after 40 in a work week. It's also curious what others did with snow emergency, county closed day. What some of the rest of you do during the emergency? How did other counties treat that time last week? What? You made them take their accrued time if they didn't come in?
Yeah, if they lived in a different county and they were not able to come in or chose not to come in,
Did you close it all?
yeah, Monday.
What happened that day?
The people that, like, non-essential were not able to come in, and the essential were full to come in. So on Tuesday, we had a late start, so those of us that made the attempt to come in, we got paid. Where the ones that did not come in at all, they would take a full day. That was the people's discretion too. People were upset because they thought they should only take 6 hours, or they should only, they didn't have to take a whole day because we didn't have to work a whole day. So that was a big issue.
What'd you do in Jasper?
If the commissioners close the roads, then the employees get a full day. And you do not take anything off of personal time or anything. You will, if they declare that emergency, then you are cleared for the day.
Okay.
We do have that policy in our handbook.
Anybody else do anything differently or? Nope. Okay, here's one. Employees are required to punch the clock on the computer. When employees forget to punch in or out, and a manager has to make an adjustment, they are docked 15 minutes. Is this legal? Why would they get docked? Just for the fact they forgot? Whose is this? Yeah, how,
It was like an honor system, at the place I used to work, it's not in the county,
okay,
but it was like an honor system, and people that came in late could essentially forget to clock in, and then later have the manager adjust it back to the time they were supposed to be there.
oh. Well, under the FLSA, there's a 7-minute rule. And the 7-minute rule is if you come in at 10 till, we round back to the quarter hour, so you get credit for 15 minutes. So we don't want people clocking in early. We don't want them clocking in more than 7 minutes before the start time. So in fact, we want them clocking in at the start time, close to the start time. There's, on the other side of the pendulum, there's a 7 minute after. So if they are 8 minutes late, then you round to the quarter hour after. So there is that penalty for coming in late. But as far as just forgetting, I don't know. It sounds like somebody's manipulating the system a little bit to do that, or a punishment. But we need to have a policy that says we've adopted this 7-minute rule, and we're telling people don't come to work and clock in before 7 till. Don't be, staying over till 10 after so you can get paid for another quarter of an hour. So that needs to be addressed in your policy. Council approves salary for an employee. Commissioners deny the hiring of the employee. Can a judge order the hiring of a said employee? Who's this? We need a little more information.
The council, as read tonight, just perhaps approves a salary line for a new hire in the circuit court. Commissioners have a hiring freeze. Commissioners, the circuit court comes asking for permission to hire this new employee. Commissioners deny the request because of the hiring freeze. The judge sends a court order that he is going to hire this person whether the commissioners approve it or not.
Has the money been budgeted and appropriated by the council? By the council. I had this discussion with Bruce Hartman from State Board of Accounts a while back. Now, I know some of the counties wanted to implement hiring freezes in the county. Essentially, what his recommendation was to do that, you really need to take the money away. Once an auditor, clerk, sheriff goes before council with their budget, including, back to that statute, the number of employees that they've approved and authorized for that office, then once that budget's been appropriated, they have the authority to hire and put somebody in that job. Some councils have tried to implement policies that say when the job becomes vacant, you can't hire. But if I've got the money there, according to Bruce, that's been appropriated. That's now in their budget, unless the council passes some further restriction, which in my view would be something like, if you get a vacancy in your office, and a person leaves on Friday, at that time, the money left in that line item reverts back to the general fund, and you, office holder, have to come back to the council and request a reappropriation of that money, because there's no money in that fund, in that line, to pay for a new employee. In my view, that's the way you would have to set up your policy to enforce, quote, a hiring freeze. And judges get frisky enough the way it is without commissioners trying to dictate to them some kind of a policy. And I mean, the judges in and of themselves are a tough nut to crack, to accept that there are certain policies that apply to everybody. And I've seen this memo from the state that has believe it or not, has a picture of a duck at the top of the paper. Looks like a duck, walks like a duck, but guess what? It's not a duck. These employees are the employees of the circuit. So we throw this fairy dust again, buckets of it over all these people. And these are my people now. You can't tell me what to do. They're not county employees. They're employees of the circuit. I'm thinking, what kind of a cloud is that? The circuit going to get sued? Is the circuit going to pay unemployment compensation? If they're employees of the circuit, how can they get health insurance? To get health insurance, you got to be a part of the contract that the commissioners sign that says only full-time employees usually get health insurance, or Affordable Care Act employees, if you work 30, you get health insurance. Not just fairy dusting it out there that, you know, you're all, I'm a state employee, correct? Judge is. But these county people retire from the county. They're on what? PERF. To be on PERF, what's that require? You have to be a county employee. They're not a state employee. So there's all these little tests along the way that say county employee, and then they say, they're employees of the circuit. There's a auditor called recently with, you know, council's got a policy that says probationary employees for the first 90 days are paid 90% of the full-time salary that's appropriated. So they get 10% less during that period. Judge says, no, I'm not doing that. I'm going to mandate it. Well, here's where we get these conflicting statutes where you've got some pretty solid grounding in the statute that says the council sets compensation for all these funds. Where are you paid from? Highway. Where are you paid from? General fund. Who sets the salary for those? Council. So, you know, at some point, you know, I would hope someday that, I'm not counting on the legislature to fix this, but I would certainly hope there would be some worthy case that would get litigated so that we would have some definitive answer for people to have. I've often said I couldn't be an elected county auditor in this state for more than about 10 minutes. They would have me out the door because I would not be paying people without some authorization to do that. So if the county council passes an ordinance that has certain stipulations, then I would not issue a paycheck. And that's, well, we're going to mandate it and you're going to be in contempt of court and you're going to be in jail. Well, if that's what it takes to get the attention of some people, fine, but I'm not going to be paying people for not following the policies or paying them when they're off work. Now, that's the one thing that does get their attention. You know, Judge, they're out of time. You can't just order us to pay people. They burn up all their sick days. They burn up all their vacation. There's no holidays. They're out of paid leave. Well, I want them paid. Where do I take it from? What's their available paid leave? Can't do it. I'll get off that soapbox, but that is, to me, that's the common thread that comes through time and again in these meetings we have, and as we talk about trying to administer policies in some kind of a standardized way. And as you think about it, the policies ought to be there to help people and provide them with some guidance and not be there and looked on as being somebody's trying to boss me around or being punitive. And believe me, whenever there's a problem that people want some help on, well, this lady's been gone forever. I don't know when she's come back. Should she be on FMLA? Well, Judge, what'd you do? Well, I need, we need some help here. We need a policy. Bingo. Here we go. Well, let's talk about the FMLA for a little bit. Page 17 in the handout, there's a brief summary of the family and medical leave, which basically sets out that employees are eligible and entitled to 12 months or 12 weeks in a 12-month period for the birth care of a child for newborn within 1 year of the birth or placement, care for the employee's spouse, child, or parent who's become seriously has a serious health condition, or a serious health condition that makes the employee unable to perform the essential functions of his or her job. And there's additional time for those people who have been called to active duty, or time to take care of a family member who's been injured while serving in the military on active duty. That kind of in a nutshell is what they're eligible for, and then it's a matter of determining who's eligible and for what. We have to work for 12 months, 1,250 hours in a 12-month period to hit the qualification. In most of the handbooks that we have assisted counties with, this is probably the most detailed and longest policy in the personnel handbook. Kim's got one with her. How many pages does the handbook dedicate to the family and medical leave? No. $20 pages out of about 70 maybe pages. It's a long policy. It gets a little complicated, and there's interplay between your other policies, particularly your paid leave policies and any unpaid leave policies that you have. So let's look at this hypothetical. County jail officer's been off for 6 months with a workers' comp back injury. The sheriff does not have any medical information to determine when or if the jail officer will be able to return to work. After learning that the time had not been designated as FMLA leave, the sheriff informed her that she was eligible for 12 weeks of FMLA that would run concurrently with the time off on workers' comp, which you can do, by the way. You can run workers' comp time concurrently with FMLA as long as you give notice. After 12 weeks of FMLA, the sheriff decides to offer the jail officer a light-duty job in the jail control room. The jail officer refuses assignment, claiming she is not qualified for the position. The department has no job descriptions for either the jail officer or the control officer positions. What would you do? How can the sheriff determine whether or not the jail officer can perform the essential functions of the job? What do you think? Yes.
I would say first they do need a job description, and secondly, since this was a workman's comp injury, they would have to have an examination by their physician and determine whether they have any restrictions.
First, they would need to have a job description for the position, and secondly, an examination to see if there were any restrictions to that. So the job description has a lot of utility in terms of particularly the FMLA, the ADA, and workers' comp. What are the requirements of the job? What are the lifting requirements? Are there driving requirements? Am I seated for long periods of time? Do I have to walk, stand? How much physical exertion do I have to endure in this job? So we need, one, what are the job functions? Then we look at this control job versus the jailer job. Are there significant differences where one, you couldn't be trained to do both jobs? And I think in this example, the answer was yes. In fact, the control room job was less physically strenuous than the jail officer job, where they may have to affect, a an arrest or come to the aid of a fellow jailer or whatever it may be. So there wasn't that physical requirement and risk to injury as much in the control room as there would be in the jail. Will the medical professionals rely on the employee's version of what the job entails in the absence of a county job description? Yes, they will. They will. And, who's in charge here? Sometimes we'll see, employees bring in some kind of a slip from their doctor saying they can't perform the essential functions of the job. Did the doctor look at the job description? Did they make some evaluation based upon what you told them the job was? Or are they taking the word of the employee and letting them tell you what the job is? Or in some cases where the doctor starts out the examination with, do you need some time off from work? No, I'm going back. But there's this to deal with. So you need to have the job description in place whenever someone is going on FMLA or request FMLA, that you send the job description along with the medical certification form with the employee to the doctor, so that there's this interactive process for the medical professional to review the request versus what the job is. If somebody's going in for surgery, that's easy. Somebody's having a baby, that's easy. But the ones that are hard is I'm stressed out. I'm suffering with anxiety, or I've got these other issues or problems. That's hard. The employees have migraine headaches. You can't see them. That's hard. We're not saying they don't have them, but sometimes we've seen those kinds of ailments used to the benefit of, I just need to be off work, and I'm having a migraine today, to the point of, we can't do anything else, but we see them out shopping, bowling, putting a roof on their house, things like that. And we say, well, wait a minute, you can do those kinds of activities, but you can't come to work. What's your responsibility as an employer? If they've been off work for more than 3 days, we need to be sending them the FMLA medical certification, take to their doctor, have the doctor complete that based upon what their job is, comes back to you. Now, it's complete, it's thorough. You're making the call that they're eligible for FMLA, you put them on FMLA, okay? They've got 12 weeks coming, they got it, that's easy. Where you have some suspicion that they don't have a legitimate claim for FMLA as a serious illness or injury, you can order them to submit to a second medical opinion with a medical professional of your choosing that the county pays for. The county is buying a medical opinion, not a regimen of treatment. And you can order them to submit to that second medical opinion. Now, here in county government, that kind of gets crazy at times. Auditor has an employee who's calling in from Las Vegas saying, I'm not going to be to work on Monday, claiming I'm got this serious illness, and faxes in a request to be off work. Well, that's an indicator of FMLA. And the auditor at that point can direct the employee to submit to a medical examination. Now, does the employee have a choice not to follow that directive? No. No. And guess what? If they don't, they've lost their coverage under FMLA. So there is some leverage that elected officials in the department have over the ordering of a second medical opinion. Now, and this happened that way. And it goes back to, again, what we started with today is the elected official, department head, is the hiring authority, and they need to direct that to happen. This particular employee was going, well, she can't tell me what to do. I'm going to go up and talk to the commissioners. And then she got her one buddy commissioner was giving her information that was 180 degrees opposite what she was told by her auditor, and it was wrong information. Well, I'm going to listen to him. He knows what he's talking about because he agrees with me. Once we learned that she didn't go to the medical doctor for the exam, we self-reported to the DOL. Said, look, this is what happened. What's her rights under the family and medical leave? Well, if it happened the way you said it did, then she has lost her coverage under the family and medical leave, and I'm giving the supervisor out of the Fort Wayne office says, I'm giving all the field offices her name and her job, and if she comes in and files a claim of violations of family and medical leave, they're directed to ask her one question, and that is, were you ordered to submit to a medical examination by your employer? And if she answers yes, and she then is asked, did you go? And she says no, it's going to be game over. You're done. And that's basically how it ended up. She ended up suing the county and lost. But it is that documentation that you need and the understanding that you have when you order those things to happen. Now, you can order up a second medical opinion, and it comes back, and it is opposite of the one you've got, say, from her or his medical provider. Well, the good news is you can choose which one you want to take. But if you've got a reliable medical professional that says this person can come back to work, you can order the person back to work. But again, you need to weigh all that out, look at it in terms of how other people have been treated under similar circumstances. Hypothetical 3, a maintenance worker, park maintenance worker with 8 months of full-time employment notified the commissioners he was diagnosed with prostate cancer and would be undergoing treatment over the next several weeks. He does not qualify for FMLA and does not have any available paid leave or unpaid leave time. He's been an excellent performer and would like to keep his job. The commissioners would like to make some kind of accommodation but are restricted by county policies. What would you do? Well, how about an unpaid leave policy for new hires that don't meet the threshold? That's a choice. That's going beyond what you're required to do. Just bear in mind that if you have that policy, it's got to be a policy that's applied to all employees in a fair and non-discriminatory way. How about other employees donating their paid leave time directly to the maintenance worker? Bad idea. I know it sounds, well, we were talking and we've got all this time built and we'll just give them our time. Not a good idea. If you want to set up a method to be able to give time, it's preferable to set up a sick bank where the days can be donated and they lose their identity. Otherwise, you face, I think you're going to see several repercussions from this. One is you're going to have certain people going with a cup in their hand, door to door, asking for buddies to give them time off once they've exhausted all their time. And it may or may not be legitimate. And in some cases, you may have employees who have had some kind of a disciplinary history with their office, department head, elected official, and are about ready to be terminated for absenteeism. And the department head's ready to write this letter that says, you've exhausted all your paid leave and it's time to come back to work. And if you're not here Monday, then you voluntarily resign. You can't do that. Susie and Linda and Billy and Bonnie and everybody gave me their days. I've got more days. Where'd that come from? It's much better to have a policy where voluntarily, if I want to put in an unused sick day into a bank that is available for people who've been on FMLA, still experiencing a serious illness or injury, out of their paid leave time, that they can apply to use the time out of the bank. And it's not a matter of picking and choosing, I like Wanda, I'm gonna give her time, but I can't stand Joe, so I'm not gonna give him any time, which sets up again potential discriminatory practices. You want to give her a day?
Sick bank, but it seemed, and everybody just gave, and there was just 6 months in the game, it's the way they needed it. And it was always the same people that needed it every single month.
We were in the city, when she worked in the city.
So it got to be, everybody was mad, well, we want to give it specifically to somebody, other than this person always gets it. So
Yeah.
it's never a win-win situation.
The only thing you can do is restrict the amount of time that any one employee can have during a certain period of time. Otherwise, you set up that abuser person that's going to milk the system and manipulate and get it all. But you can do it so it's intended to really do some good for those people who are like this good employee that you want to keep. And otherwise, you might be facing a situation where you got to come to work and we just don't have any way to let you off. Another piece that's not here, which I mentioned earlier, and that is some of the new rules under the ADA, Americans with Disabilities Act, do provide for your ability to provide some unpaid leave as a reasonable accommodation under ADA once they've exhausted their FMLA. Now the kicker here is, it's not every person who exhausts FMLA. There has to be an expectation that they're going to return to work at some point in time. It can't be some kind of a permanent disability where they're never going to be coming back to work and they would be given some extra leave time. If you've got medical information that says this person will never be able to come back to work, then there's no way we can make that kind of an accommodation. And these things otherwise would go on indefinitely. And oftentimes people, it's not only to hold on to their job, but to maintain the health insurance and be on the county's health insurance. So that's another possibility under this hypothetical. Number 4, administrative assistant in the engineer's office files an harassment complaint claiming that the behavior, this is off FMLA, by the way, causing a hostile work environment, Tim mentioned this morning. Specifically, she alleges that her boss, the county engineer, shows favoritism to another administrative assistant who works in the same office by giving her very little work to do, having long lunches together, sometimes returning to work smelling of alcohol, and having closed-door meetings when giggling and laughing can be overheard. The administrative assistant submits the payroll for the office and claims that her counterpart misses a lot of days beyond those allowed by the county policy. But she always receives a regular check without recording the time not worked. She also says that inappropriate emails and websites are left for viewing on a computer that is shared by all in the office. She complained to the engineer, but he brushed it off as a jealous thing. To complicate matters, these employees work at a private office of the engineer, not the county building. The commissioners now have a written complaint. What to do? Okay, let's play pretend. You're all county commissioners. What would you do? What would you do? Huh?
Call the county lawyer.
Call the lawyer. We're taking it under advisement. We're going to call somebody. Call the attorney. What's the attorney going to say? They're going to say, what's the handbook say? What should the handbook say? There should be a policy there. This is another one of those federal rules that you need to have a sexual harassment policy. It goes back to Title VII of the Civil Rights Act of 1964. You've got to have a policy. And the policy needs to describe what is considered sexual harassment or hostile work environment, which Tim covered those things this morning. Your policy also should provide a way for employees to complain. It also should provide some notice of how you're going to investigate that policy, and that there are possible sanctions for employees who are in violation of the policy. Now, under this particular scenario, which I find to be a little more clear-cut, where the engineer works for and is appointed by the county commissioners, there's a direct line of authority over this employee. And they can take the bull by the horns, conduct the investigation, and if it's found that there is violations of the policy, then they can take the appropriate disciplinary action. The problem becomes bigger if this complaint is coming from an administrative assistant to a public defender, attorney who has a private law office down the street where the county employee is working. Now who's in charge? We filed it with the commissioners, just like it says. Now what happens? Well, I can tell you the commissioner said, holy moly, we want to deal with this. You know, let's call somebody in to do an independent investigation. Okay, we'll do that for you, commissioners. What about the responsibility of the courts? Well, let's talk to the judge. Doesn't have anything to do with me. No, this is out of my, I'm not in charge of public defenders. They've set up their own board. I'm out of it. All of a sudden, I don't have any authority to do anything now. You know, we sure have it when we want to do stuff, but when we don't want to do stuff, we're out the back jack. Well, the commissioners ultimately investigated that case and found that there was a bit of this hanky-panky stuff going on. And the attorneys were showing up about half in the bag in the middle of the afternoon, making all kinds of lewd comments and acting like it was a locker room. And it turned out that a couple of them got dismissed, along with the one administrative assistant who wasn't doing the work. A lot of liability here. So I guess, word one, you need to have a policy. You need to be able to have an unbiased, independent investigation and come to some resolution. In this case, we signed a contract with the county attorney, investigated, and returned our findings and recommendations to the county attorney, and maintain confidentiality by doing that way and not giving a report directly to the county commissioners. The county attorney has client privilege with his commissioner clients. But once the report's given from an outsider to them, then it breaks the chain, and that can become a public document, which you do not want that on the front page of the paper the next day. There was another issue here in that the building was owned by county engineer, or really public defender, and this also brought some liability to the law firm in that case, because it was now a joint employer relationship where some of the people in that office were also doing some part-time work for the attorneys as well as doing their county work. Any questions on that one, or these things just happen in a few counties, or? Okay, family and medical leave quiz. Another true and false list here. An employee eligible for FMLA is entitled to 12 weeks of paid leave for certain family and medical reasons during each calendar year. False. Someone said unpaid. And what else is iffy in this statement? Calendar year. Now, absent expressing your policy in another way, the Department of Labor would say their calendar year. That's their take if you don't have the policy. If you just adopted the Family and Medical Leave Act on its face, it would be a calendar year. Most counties have elected to have it on a rolling 12-month period, not a calendar year. Why? Because someone could basically begin a family and medical leave in October and then start another one in January and run 24 weeks together. The rolling calendar year would mean I could start October 1, take 12 weeks. I would not be eligible until October 1 of the following year. And it would always roll. I didn't need it next October 1. Oh, something happened in the following May. That would roll the date to May, and then the 12 weeks would go forward again. And that's preferable to running on a calendar year. It's unpaid leave under the FMLA. 2, workers' comp leave may count as FMLA leave if the reason for the leave is due to a qualifying serious illness or injury, and if the employer properly notifies the employee in writing that the leave will be counted as FMLA leave. True. 3, employers are not obligated to provide FMLA leave until the employee makes a request for FMLA. False. This is probably the one of the biggest misconceptions of the FMLA, well, they didn't come in and ask for it, so we didn't give it to them. My buddy John Bowers, a lawyer up in Fort Wayne, said he had a call from a county and state, and the county attorney called him about FMLA. He says, you know, John, we've never had an FMLA case. He said, oh, wait a minute. FMLA was passed in 1993. 21 years, no one's ever had a child? No one's ever been in the hospital? Well, yeah, but they've never been on FMLA. Why? Well, we just didn't know how to do it. So it never happened. I'm thinking, wow. I was at a department head meeting, and he says, you know, this Affordable Care Act's going to have a long learning curve to it. I said, yeah, so does the FMLA. 21 years or so. But we as employers, once you have knowledge that it may be a qualifying FMLA condition, serious illness or injury, you're responsible for triggering the FMLA. If somebody's going to the hospital, it's easy. It's FMLA. And here are your medical certification forms to take to your doctor. Now, part of the good news with FMLA is the government does provide us with some pretty good forms to help process FMLA leaves, medical certifications and notices that we give employees that are on FMLA. Look at the calendar, you know, when you're supposed to send them another notice about coming back to work or letting us know about your medical condition, when it's over, what's going to happen. Those kinds of things are all spelled out in those forms, and it's highly advisable to use them. The problem is when we don't give notice, we can have employees come back later and say, I never got my FMLA. Scott County had some guy in the highway department who was off for about 2.5, 3 years. Exhausted everything. He was on workers' comp for a minute. And the workers' comp doctor said, you can come back to work. Came back to work. And then something else happened, and he's off again. He was like 12. Has he ever been on FMLA? No, this is like August. He's been off since last November. Did you give him notice about FMLA? No. I think we better do that. So we gave him the notice. He ran out the 12 weeks. Doctor says you can come back to work. He's finally coming back to work. He shows up. And the day he shows up, the P-Mobile drove into the parking lot of the highway garage to test for drugs and alcohol. Well, he came in and I can't do this today. I just went to the bathroom. Well, you sit here on this bench and drink some water. We're going to test you. They have their lab right there, the whole bit. Take a sample. So the supervisor's kind of huddling away from where he was sitting, and the next thing they see is payloader's coming through the door, and he's laying next to it. He's taking one for the team. I didn't see it coming. And it was like falling in the floor. Now they're calling the EMTs. They're taking him to the hospital. And the last thing the supervisor said was, he's supposed to be submitting to a drug test while he's there. Make sure you get a blood sample for this test. Of course, that was the one thing that went in one ear and out the other and never happened. Now he's off again on a workers' comp claim. Again. And it got to the point where that ran out and he wouldn't come back to work. He had exhausted everything to where they were finally able to write the letter, it's time to come back to work. And if you don't show up, you're done. But that took a good 2.5 years. But without the notice and people who don't want to work, they know how to reach out and grab these policies, claim things that may not be true or accurate or just downright false, in order not to work. And it's like, I'm stressed out. You're stressed out because you're about ready to be terminated. And they'll come in and say, you know, I'm suffering from this anxiety and I need to be off on FMLA for stress. Here we go. Once they've given you those words, then you got to stop and take pause. If they're eligible for FMLA, you need to stop. Don't take an adverse action during that period, or it's going to be some kind of a retaliation claim where some judge will look at it and say, well, the time between them asking for FMLA and you let them go, it's got to be the reason you let them go. It's because they wanted to, you know, get their rights under the FMLA. So you lose, county. So I always say if there is a disciplinary problem that needs to be dealt with, deal with it at the time and move on and not let it linger. Because employees sometimes have this kind of sixth sense. Just when you're ready to drop the shoe, then here comes this FMLA request, or here comes this harassment complaint, or any other way that they can look to your policy and try to protect themselves.
So if they return from FMLA, they're at their limit, and let's say the first day they're at work, they've been fully released by their doctor and they exhibit signs of, they're telling you they're not in a physical condition to be working, they're in pain. Can you ask them, is it appropriate to ask them to go
If
see
you-
their doctor? Is their doctor aware of it?
Absolutely. I mean, as the employer, you have a responsibility to maintain a safe workplace for the employee and other employees, that they're not posing some kind of a threat to the safety of other people in the workplace or citizens. I'm not going to let that guy hop in a car and drive, or a truck, or wear a gun. You need to be, and that's the thing, they need to be released to perform the full range of duties. And these medical professionals need to understand what the full range is of the duties of their job and make the decisions against, again, what the job description says and entails, as opposed to the employee telling that medical professional what they think the job is. And most of these job descriptions nowadays include the physical efforts and work environment under which all these duties are performed. And that becomes key in terms of how you make your decision. But you have to weigh the risk of somebody posing a threat to themselves or others in the workplace against them just saying, you know, I can come back to work. Particularly when you observe them not, you know, being able to perform those duties or having some great difficulty in doing so. Number 4, employees are eligible for FMLA leave if they've worked for at least 12 months of work for 1,250 hours over the 12 previous months. That's true. That's the bar. That's the qualifying conditions. An employer may require that an employee is on FMLA leave for his own serious illness or injury. He or she shall not be engaged in outside employment. True. Without that policy, and you find somebody working in an outside job, you can't do anything about it. But you need to have, if that's going to be your position, you need to have that in your policy. Now, what this says and what it doesn't say, it says for the employee's own serious illness or injury, theirs, not taking care of a family member. So if I'm on FMLA, assisting a family member, taking them to the hospital for treatments, I don't have to give up my part-time job. But if I have a serious illness or injury that prevents me from working from the county in my job, I cannot be out working at another job. Number 6, an employer cannot require employees to use accrued paid leave such as sick, vacation, or personal days for any part of the 12-week leave. It's false. You can require that they use all of their available paid leave and comp time during their FMLA. And the employee says, well, I don't want to use all my vacation. I want to save it. You know, I just made a down payment for a cruise. It's our anniversary this fall. I want to keep Pam happy. I don't want to have to burn up my vacation time. I want to be able to go on this cruise. So I'll take it unpaid. If your policy says you shall use all your paid leave, there's not that discretion. But if you have a policy that says you can save your vacation time or so many vacation days at your choice, you can have that policy. Typically, the policies require that they use their available paid sick time. That's what it's for. And then it's up for debate. Some employers will say, you can save your vacation, you can save your personal days, you can save your comp time, or any combination of those. But that's an individual employer call. It's one of the few calls that we have under the FMLA, is how we interplay, or how the different paid leave policies interact with the FMLA. Number 7.
Let me ask, does the employee have to ask to hold back that week if it's in the policy?
Does the employee have to ask to hold back a week if it's in the policy?
They're on FMLA, they have 4 weeks. They have to, and it says if you want to hold back a week, you have to ask us.
If they want to hold back a week and the policy says that, they have to ask you, yeah, they need to ask you.
If they don't, if they use up their 4 weeks and they're off 12, they'll say, well, I wanted a week held back, they can't go back and change it after that, right?
I would say no. I would say when they start, that we outline what the terms and conditions of that leave is going to be from the very beginning. So there's not this debate at the end or trying to change something after it's already in place. Number 9, an employee is not required to maintain group health insurance for an employee on FMLA leave. False. Now, they're supposed to make arrangements to take care of any portion of the premium that's their responsibility when they're on FMLA leave. And you can have a policy that says if you don't, you lose your health insurance, which is kind of real dumb if you're on FMLA leave and lose your insurance. But I think it's the safe route is just keep it active, even if they don't pay, and then take it out of their wages if they come back, or go to small claims and get it back if they don't return to work. But you're the good guy here. You're going beyond the call of what you have to do. And number 10, the FMLA does not permit employees to take leave on an intermittent basis or to work a reduced schedule, such as to care for a newborn or newly placed or adopted or foster care child. False. Intermittent leave is part of the FMLA. And it's one of the things that was changed in a recent amendment to the FMLA leave. The minimum increment now is 1 hour. They can take intermittent leave in 1 hour increments. Previous to the change, excuse me, it was the minimum increment for what your other county policies had. So if you had a vacation policy that said minimum increments of a half a day or 4 hours, then that was the minimum increment for FMLA. Now, you can still have those minimum increments for those other policies, but if it's intermittent FMLA leave, they can take it in 1 hour increments. And the intermittent leave is another challenge to track. And the best way to do that is, if it's starting today, January the 22nd, and they're going to go on FMLA leave, never been on FMLA, their leave starts today, that you look at their regular work schedule for the next 12 weeks and add up the number of hours that they are normally scheduled to work over the next 12 weeks. And that's the number of hours that they would be eligible to have over the next 12 months until January 22nd of 15.
So it changed for newborns, because it used to be that you had to take it all at one time.
Oh. I stand corrected, right. Newborns, you have to take it within that year of birth.
But it can't be intermittent, it would always have to be all at one time, so did that change?
That shouldn't have been in there. I should have given a serious illness or injury or taken care of someone. If it's for yourself, it's 1 hour.
But for newborns, you can't take intermittent leave.
I think it would only be under certain circumstances that you could. There'd have to be some kind of a medical supported reason that you do that. But that's worth following up on.
It's always been you had to use it all at one time, so I was just curious.
Does anybody have any questions over the FMLA? Any others? Yeah.
I thought FMLA allowed 480 hours in the time of calendar year, of leave. And that includes the intermittent, so they have 480 hours they can use.
If, for example, I was on FMLA for 12 weeks and I worked a 35-hour work week, my day's 7. If I'm on a schedule that calls for 8, then a day is 8 hours. So it's going to be a different number of hours based upon what my work schedule is. And you get into those crazy schedules that police and fire have, then again, it's going to be a different total number of hours if they're doing it on an intermittent basis.
Okay, so they're going by 12 weeks and not the 480 hours.
Right. You're eligible for 12 weeks, work days.
60 days.
Not, if you don't work Saturday and Sunday, it's not those days, so, in terms of the number. Anybody else?